அந்த மவுஸ் ஒன்று எனக்கு నేను చెప్పుకోగలరు స్టార్ట్ చేస్తారు ఇంట్రడక్షను నోట్స్
Yes, hello? Yeah, please. Settle down. Once you come into the class, as usual, you have to learn something new. So you have attended the class, not for the sake of the class, to avoid fine. Avoid, yeah? Huh? Yes, sir. So avoid the fine. You are coming into the class. Right? Yes, you are in the red job. Finally here. Fine avoid பண்ணனும்னு சொல்லி எல்லாரும் class பண்ணிருக்கோம். You don't want to listen the class. Just avoid the fine. You came here. Right. Final year. General. You are having 3 subjects இருக்கு. 3 subjects you are having. And honors you are having 5 subjects. Right. So one paper is for 100 marks, one paper is for 80 marks, one paper is for 50 marks. That is for general and honors. Additional is there. So you have to write 2 exams. That is for 100 marks and 100 marks. So finally the first paper enna criminology and penology and victimology. This is 100 marks for you. External 100 mark paper. Second one is professional ethics paper is there. That is for 80 marks. Third one is alternate dispute resolution area. It is 50 marks paper. They will ask you 5 questions. You have to write 4. 50 mark paper. Then subsequently for honors you are having 2. International trade law is there. 100 marks paper, and insolvency and bankruptcy laws is there. It is for 100 marks paper. Right. Now, the recent trend which is going on in the university is, if you write story, you are bound to fail in the final year. They are not even pausing you. Previously, என்னன்னா நீங்க ஏதாவது கதை எழுதினா கூட finally normally used to write story. No, wonderful story writers are there here. Wonderful story writers are there here. You are writing some stories, right? You are pausing, but this is not the case. Remember, if you write stories here, 2 years will be wasted for you. Question paper ஏதாவது எழுதலாம்னா இந்த வாட்டி முடியாது. Why? Because external professors are coming and evaluating your papers. First you keep it in your mind. இத்தனால you have written something, but write right, reasonably, unreasonable. Reasonably, unreasonable, right. ஏதாவது எழுதணும், கதெல்லாம் எழுத முடியாது. You have to write the topic. So, how many papers are there for general? 3. Honors 5. இது இல்லாத வைவா இருக்கு உங்களுக்கு. வைவா 300 marks will be in the hands of the professors. Right. So இங்க ஒரு அட்வான்டேஜ் இருக்கு. தெரிஞ்சவா இருந்தா வைவால questions கிடையாது. No questions for you. If I don't remember your faces, you will be having viva for 6 days. 6 రోజులు உங்க மூஞ்சி தெரியலன்னா எத்தனை நாள் இருக்கு வைவா உங்களுக்கு? 6 நாள் வைவா இருக்கும். 6 days you will be having your viva. Right. So, yes. 6 days you will be having viva. 30 to 40 questions you will be facing from the professors. Everyone, నువ్వు రావట్లేదు కాబట్టి నీకు సేమ్ అంతే. whoever is not coming to classes regularly, ఏమన్నా ఇత్తనాలు you are out of our control. Now you are in our control. Right? அதுவும் எங்க ஒரு 5 நாள் தான், அப்புறம் ப்ரொஃபஸர் இல்ல, யாரும் இல்ல, அவ்வளவுதான். ரைட், ரைட். So today I am going to deal with alternate dispute resolution. ఎక్కడ చేయాలమ్మా? ఎక్కడ నొక్కాలా?
దూరం బయట எங்கே அங்கேயே இருக்கணுமா? ரைட் ரைட், ஒரு நிமிஷம் உண்டு. பேக். ரைட் ரைட்.
Yeah, please. Yeah, please. So, I am dealing with alternate dispute resolution. Another thing, I am giving you a hint is also there. யாராரு எந்தெந்த சப்ஜெக்ட் வராலோ kindly know the professor's name also. Why? வைவால கேப்பா யார் ஏடிஆர் இருத்தான்னா லைனா மூஞ்சி பாத்தங்களானா? ரைட், வெரி குட். என்ன பேரு? ஸ்ரீகாந்த் சார், ஏடிஆர். So whoever is taking, you know the principal name, right? You know the principal name, honorable chairman's name, president name. Right. You have to know the names also. Professor will ask you which subject, who is taking. అన్ని అడుగుతారు అన్నమాట. எல்லாம் கேப்பா, எல்லாம் கணிசம் தெரிஞ்சு வச்சுக்கோங்க, யார் வரா யார் வரலன்னு சொல்லி. ரைட். So now one subject is there, alternate dispute resolution. Right, ADR. That means normally if you have a dispute, you are going to courts. You know, if you are having a dispute, ஏதாவது problem இருந்தது, ஏதாவது issue இருந்ததுன்னா you are going before the courts. Right. Different courts are there, you know. For civil courts are different. High court is there, Supreme Court is there. Now you are having certain civil rights are there, contractual rights are there, and your fundamental rights. உங்களுக்கு நிறைய ரைட்ஸ் இருக்கு. என்ன ரைட்ஸ் இருக்கு? சிவில் ரைட்ஸ் இருக்கு, லீகல் ரைட்ஸ் இருக்கு, ஃபண்டமெண்டல் ரைட்ஸ் இருக்கு. ஃபண்டமெண்டல் ரைட்ஸ், if anybody infringes your fundamental rights, you are going to high courts and supreme courts. இது நடுவுல கோர்ட்டுக்கு போகாத, you are not going to the courts, but you are resorting to certain mechanisms. கோர்ட்டுக்கு எல்லா டிஸ்பியூட்டுக்கும் கோர்ட்டுக்கு போனா என்ன ஆகும்? டைம் இஸ் வேஸ்டட். டைம் இஸ் வேஸ்டட். யூ ஹாவ் டு அப்பாயிண்ட் எ லாயர், அட்வொகேட்ஸ், மணி இஸ் வேஸ்டட். ஸோ இதெல்லாம் அவாய்ட் பண்றதுக்கு நம்மளுக்கு செப்பரேட் மெக்கானிசம் இருக்கு. அது என்ன சொல்லுவாங்கன்னா ஏடிஆர், ஆல்டர்னேட் டிஸ்பியூட் ரெசல்யூஷன். ஆல்டர்னேட், தட் மீன்ஸ் கோர்ட்டுக்கு போகாத, you are going before the some other person, right? So you are going before some other person and you are resolving the disputes. You are not going to the courts. For example, there is a contract between A and B. Or a contract with A and B. And the contract, you know, if any dispute is between A and B, contractual dispute, where this person has to go? Very good. Civil courts. Civil court ku pona eda dispute enga pona civil court ku pona civil court la pona what enna agum time 2 years 3 years 4 years agum civil court ku velte em avutundi ante 3 years 4 years 5 years. Why? Courts are bound by law. ఎందుకు అంటే ఎదుకన్నా కోర్టుకు పోనా அவங்க లా ఫాలో பண்ணுவாங்க. You know, whenever a suit is filed, suit file பண்ண உடனே உங்களுக்கு தெரியும் plaint file பண்ணணும், 30 days time கொடுப்பா return statement, again return statement file பண்ணணும், திருப்பியும் మళ్ళీ ఏమవుతుంది proceedings will go on, evidences will go on, எல்லாம் நடந்து 3 வருஷம் 4 இது நடுவுல கூட உங்க சூட்டை ஹை கோர்ட் ஸ்டே பண்ணணும். That means 3-4 years also you are not getting decree and judgment. Varadu. Once you get the decree and judgment, again enna pannala nee? You can go for appeal. First appeal is there. You will go for first appeal. Again, first appeal also, you can go for second appeal. That means almost 10 years will be wasted for you. Right. இப்போ நம்ம என்ன பண்றோம்னா, whenever you are entering into a contract, right, you are making some clauses in the contract. கோர்ட்டுக்கு போகாத நம்ம என்ன பண்றோம்னா ஒரு பிரைவேட் பர்சன் கிட்டக்கு போய் we are resolving our disputes, right? So there is a dispute between A and B, contractual dispute. A and B will agree that instead of going to the courts, we are going before an arbitrator. ஒரு பர்சன் இருப்பான், third person, ஒரு private person, அங்க போய் நம்ம என்ன பண்றோம், நம்ம dispute சால்வ் చేసుకుంటాం, நம்ம dispute சால்வ் பண்ணிக்கிறோம், ரைட்? இப்போ அந்த பர்சன் என்ன பண்ணுவான்னா ஒரு ஆர்டர் பாஸ் பண்ணுவான். அவன் என்ன சொல்லுவான்னா ஆர்பிட்ரேட்டர். தட் பர்சன் இஸ் நோன் as ஆர்பிட்ரேட்டர். அவன் என்ன பண்ணுவான், he is not a court. அவனுக்கு ஒன்றும் பவர்ஸ் இருக்காது, கோர்ட்டுக்கு இருக்கிற பவர்ஸ் ஒன்றும் இருக்காது அவனுக்கு. You don't have the powers of the court, right? Now this person is passing one order that is known as an award. So arbitratorல என்ன ஆர்டர் என்ன சொல்லுவா, award. Now I will ask you one question. Court decree and judgment கொடுத்தாவே நம்ம ஃபாலோ பண்ண மாட்டோம், அவ்வளவுதானே? Even court order is there, we are not following. Then how you can what is called follow the order passed by the third person? That means it is by your consent. நீங்க ரெண்டு பேர் ஆர்பிட்ரேஷன் போறப்ப என்ன ஒத்துனாங்க, தேர்ட் பர்சன் கிட்டக்கு போறேன்னு சொன்னாங்க, அவன் கொடுத்த அவார்ட நம்ம ஃபாலோ பண்றேன்னு சொல்லி you are telling. That means you are both signing the contract for going for the arbitration. That means you are accepting. That's why the award is binding on you. You know the contract. Whenever you are signing the contract, you are submitting your respective legal obligations to the court. Likewise, whenever you are signing an arbitration agreement that we have to go before the arbitration, that award is binding on you. How? Because you have consented that the award is final, it is binding on you. So now you can enter into arbitration agreement in two ways. ரெண்டு விதமா நீங்க enter ஆகலாம். One is contract లోనే ఒక క్లాస్ పెట్టుకోవచ్చు. You can have a clause in the contract, or separate agreement you can make for arbitration. Contract la enter ஆகும்போதே நம்மளுக்கு disputes இருந்தா we will go for alternate dispute resolution. இல்ல contract one agreement is there, you can enter into another agreement for arbitration, right? Different types of ADR mechanisms are there. For example, in labor law படிச்சீங்களா? எத்தனாவது செம்ல வந்ததா? 7-8ல. இப்பெல்லாம் 7-8ல ஆனதுனால நம்ம லேபர் லா தேவையில்லை. இட்ஸ் வெண்ட் அவுட் ஆஃப் அவர் மைண்ட்ஸ். அவ்வளவுதானே? அந்தந்த சப்ஜெக்ட் அந்தந்த செம்ல we will leave. லேபர் இண்டஸ்ட்ரியல் ஆக்ட்ல ஏதாவது இஷ்யூ வந்தா ஃபர்ஸ்ட் எங்க போகணும்? இண்டஸ்ட்ரியல் டிஸ்பியூட்ல டிஸ்பியூட் இருந்தா ஃபர்ஸ்ட் எங்க போகணும்? லேபர் கோர்ட்டா? யார் சொன்ன லேபர் கோர்ட்னு சொல்லியா? ரைட். லேபர் கோர்ட்னு யார் சொன்னது?
நம்மள கிளாஸ்
லேபர் லா ஃபர்ஸ்ட் எங்க போகணும்? கன்சிலியேட்டர். படிக்கலையா? லேபர் லால டிஸ்பியூட் வந்தா ஃபர்ஸ்ட் எங்க போகணும்? கன்சிலியேஷனுக்கு போகணும். தட் இஸ் ஆல்சோ நோ. ரைட். ரிமெம்பர். தெரியாது. ரைட். தெரிஞ்சது அண்ணா ப்ராப்ளம், தெரியல அண்ணா வைவால கூட ஏதாவது ஆன்சர் பண்ணா இன்னொரு क्वेश्चन கேட்பா. If you answer one question, you will get another question. If you don't answer, just if you keep stare at the eyes, no question. உங்களுக்கு சொல்லி கொடுக்கறா, நீங்க ஏதாவது வாய் திறந்தாங்க இன்னொரு क्वेश्चन வரும். Again you will get so many questions. So don't open your mouth in the viva. No, just for fun I told you. Right. చాలా எல்லாருக்கும் அந்த ஃபியர் இருக்கும். நம்ம ஒன்னு சொன்னா இன்னொன்னு கேட்பா. ஒண்ணுமே சொல்லன்னா ப்ராப்ளமே இல்ல. தெரிஞ்சா ப்ராப்ளம், தெரியலன்னா ப்ராப்ளமே கிடையாது. అவ்வளவுதான். తెలిస్తేనే ప్రాబ్లం, తెలియకపోతే నాకేం తెలియదు అంతే, అయిపోయింది. వైవాల వెరీ సింపుల్ టెక్నిక్, రైట్? ఇఫ్ యూ డోంట్ నో ది ఆన్సర్, యూ లుక్ అట్ మై ఐస్. ఎస్, ఐ విల్ సే గో. Look at my, if you look at another eyes, they will ask you a question. Vaivala onnum therlanna, look at my eyes, I will say go. Right. They don't want questions, that's why they are telling like this, right? Yes. So alternate dispute resolution means, yeah, please listen. Once if you come, ஒரு 15 days தான் கேட்க போறோங்க கிளாஸ். அப்புறம் நீ யாரோ நான் யாரோ, சரி? அவ்வளவுதானே? ரைட். லிசன் ஃபார் 15 days. ரைட். whether you like it or not, sit down here. Now we will go into this. Delivery of justice within a reasonable time is fundamental right under the Constitution of India. You know, delivery of justice, எல்லாருக்குமே நியாயம் கிடைக்கணும்னு சொல்லி, please last bench, please listen. So it is the fundamental right for everybody. So here the Indian judicial system is currently clutched with many pitfalls. நம்ம judiciary வந்து நிறைய cases எல்லாம் நிறைய இருக்கு. pendency of cases are there. So many cases will be there. It is pending before the courts. So if you go before the courts, again your case won't be reaching in time. That's why we are resorting to alternate dispute resolution. நம்மளுக்கு we are having one act is there. You know, if you are going and filing a suit in the civil court, you have to follow civil procedure code. Likewise, for our alternate dispute resolution, we are having one act is there. It is known as Arbitration and Conciliation Act 1996. First act enna? Arbitration and Conciliation Act 1996. Now இந்த ஆக்ட் வந்து எது மேல பேஸ் பண்ணி நம்ம பாஸ் பண்ண இந்தியால అంటే ఈ యాక్ట్ని మనము దేన్ని బేస్ చేసుకొని పాస్ చేసాము అంటే there is another law is there that is known as UN Citral Model Law. This you have to know. UN Citral, United Nations Commission on International Trade Law. United Nations Commission on International Trade Law. On this model law, we have enacted the Arbitration and Conciliation Act 1996. Right? On which model law? UN Citral Model Law. We have enacted the Arbitration Conciliation Act 1996. Right? That is the first model law. Dani base cheskoni we are going before the courts. Again, 1996 Act has been, right? Yes, repealed by another Act, Arbitration Conciliation Act 2013, 2019 new act has come into existence. Right now we are going to see different facets of Arbitration and Conciliation Act. Right, so dispute resolution process is classified into two types, consensual and amicable. First part is consensual and amicable. Second one is non-consensual and adversarial. So ADR is divided into two types. First one enna consensual and amicable. Second one is non-consensual and adversarial. I will tell the difference. Right. So first one is consensual and please switch off your phones. Whenever you are coming into the class, don't see the mobile phones. First aspect. You know why? Mobile phones நிறைய டைம் இருக்கு. எப்போ டைம் இருக்கு? லா எல்லாம் முடிச்சு என்ரோல் பண்ணா விட்டு கோர்ட்டுக்கு போக முடியாது, ஏன்னு நமக்கு தெரியாது ஒன்றும். அப்போ மொபைல் ஃபோன் வச்சு யூ கேன் பிளே பப்ஜி கேம்ஸ். வீட்டில் உட்காந்து நிறைய டைம் இருக்கு. யுவர் டோட்டல் டைம் யூ கேன் ஸ்பெண்ட் ஆன் யுவர் mobile phones. Plus listen, two types of process is there. One is consensual and amicable. Consensual and enna? Yes, consensual, consensus ad idem. That means you yourselves are accepting for that arbitration and you are settling the matter amicably. நீயே accept பண்ண எங்கேக்கு போகணும்னு சொல்லி arbitration போகணும்னு சொல்லி you yourselves are accepting that you are going before the arbitrator, you are solving the problem. Consent means you are accepting, you are going before the arbitrator, you are getting the award, your matter is settled. நீங்களா arbitrator கிட்டக்கு போறங்க, dispute resolve பண்ணிக்கறங்க. Amicably means in a friendly manner you come back. First one, you are accepting. Second one enna, whether you like it or not, you have to go before arbitration. உங்களுக்கு பிடிச்சாலும் பிடிக்காதனாலும் கூட எங்க போனோம்? ஃபர்ஸ்ட் ஆர்பிட்ரேட்டர் கிட்டக்கு போயிட்டு தான் திருப்பியும் வரணும். ஃபார் எக்ஸாம்பிள், இன் மேட்ரிமோனியல் டிஸ்பியூட்ஸ், இஃப் யூ ஃபைல் அ கேஸ் ஃபார் டைவர்ஸ் கேஸ் ஃபைல் பண்ண உடனே ஃபர்ஸ்ட் எங்க அனுப்புவோம் தெரியுமா? கன்சீலியேஷன். வெதர் யூ லைக் இட் ஆர் நாட், யூ ஹாவ் டு கோ பிஃபோர் கன்சீலியேஷன். ரைட்? தட் மீன்ஸ் non-consensual. You are not accepting for conciliation, but the court says first you go before conciliation, then you come. இப்போ என்ன ஆச்சு? நீ கன்சிலியேஷன்ல ஆக்செப்ட் பண்ணல, then adversarial court will pass an order. Adversarial means court வந்து உனக்கு இஷ்டம் இருந்தால் இல்ல போனாலும் ஒரு ஆர்டர் பாஸ் பண்ண என்ன பண்ணணும்? நீ accept பண்ணணும். So two types of process is there. One is consensual and amicable. That means you are going, you are accepting, dispute is resolved. Second one is whether you like it or not, you are going and you are getting the order from the court, you have to obey. That's it, right? So dispute resolution process are firstly classified as consensual and amicable, chosen by consent of the parties and decided amicably, and non-consensual and adversarial parties needs to consent of the opponent to refer its dispute to the process and decided by trial. Second aspect trial will be there. You always remember courts ke எப்பவுமே சட்டம் apply ஆகும். Courts will always bound by the civil procedure code. Courts will be bound by the law of evidence, right? But alternate dispute resolution mechanism la CPC follow பண்ற தேவை இல்ல, law of evidence follow பண்ற தேவை இல்ல. It is enough if they follow principles of natural justice. Arbitration la என்ன follow பண்ணனும்? Principles of natural justice. Yes? Right. So principles of natural justice. CPC won't apply to arbitration. Evidence don't apply to arbitration. It is enough. You know the principles of natural justice. கேள்விப்பட்டிருக்கீங்களா? எந்த சப்ஜெக்ட்ல? எந்த சப்ஜெக்ட்ல? சேம். தெரிஞ்சா சொன்னா ப்ராப்ளம், சொல்லன்னா ப்ராப்ளம் கிடையாது. இன்னொன்னு மறந்து போயிட்டா, ஒரு செமிஸ்டர்ல என்னென்ன சப்ஜெக்ட்ஸ் கூட கேட்பாங்க அங்க வைவால. Third semester, how many subjects you are going to learn? How many subjects you read? 5. What are they? சொல்லணும். எனக்கு இல்ல அங்க, எனக்கு கிடையாது அங்க. You read yourself and come to Viva. நான் ஆல்ரெடி உங்களுக்கு வைவால என்னென்ன கொஸ்டின்ஸ் கேட்கறேன்னு சொல்லி லீக் பண்ணிட்டு இருக்கேன் முன்னே, ரைட்? You have to know all how many subjects you learn. 30, 35, 40. Right? How many subjects you learn? General 30, honors 40. Right? Keep it in your mind. Next one. So, decided by trial, by weighing the evidence and legal arguments presented by the parties. இப்போ different types of ADR process will be there, we will see. Facilitative, advisory, determinative and combined or hybrid. These are the different process of alternate dispute resolution mechanism. Enna? First one is facilitative, second one is advisory, third one is determinative, fourth one is combined or hybrid. Right? Now we will see determinative process. Determination, it's more or less adjudication. Determination, determine, that means the dispute resolution practitioner evaluates the dispute. He will evaluate the dispute. You see, all the ADR mechanism, third party will be there. He is known as arbitrator, conciliator, mediator, whoever it may be. So, the dispute resolution practitioner evaluates the dispute and makes a determination. That means, இவன் பக்கம் என்ன எவிடன்ஸ் இருக்கான்னு பார்ப்பான், அந்த பக்கம் என்ன எவிடன்ஸ் இருப்பான்னு பார்த்து அவன் என்ன பண்ணுவான்னா ஒரு ஆர்டர் பாஸ் பண்ணுவான். அத என்ன சொல்லுவான்னா அவார்டுன்னு சொல்லுவா. ஆர்பிட்ரேஷன் ஆர்டர்ஸ் எல்லாம் இருக்காது, ஆர்பிட்ரேஷன்ல அவார்டு இருக்கும். ரைட்? So, example of determinative dispute resolution process of arbitration, expert determination, private judging. You have to understand one thing. Arbitrator will weigh the evidence of both the parties. Both the parties who are going before the arbitrator.
She's coming.
She is there, huh?
Oh, right.
Right. Next is I think pleadings will be there, right? Huh? Drafting and yeah, you can have a good class, right? Yeah. Mohan?
If it's not audible, you can use these also. These also. This is also coming. This also. Look at this.
Actually, not if it is actually word. Uh-huh. That's fine. I just use this. But no need to open right now. I'm just gonna say the instruction that I'm doing. No need to open right now. Today you will not need, you need not open it.
But now, while you are taking
This one. Maybe.
Good morning, everyone. Welcome to your last semester of your academic year. And congratulations for sustaining so far. So, I'll introduce myself. I am Danya Vai, and I will be taking class for your drafting, pleading, and conveyancing paper. You can sit, relax, Nimbadiya in the class paper because for your kind information, this is not an exam paper. But this, what you learn from the couple of definitely helpful for if you wanted to practice or if you wanted to go in the legal field, this will be of great use if you pay attention. Clear? So in this couple of classes, you will be learning. So these are the rights, individual order. Rights, liabilities mentioned Pandana. It's a substantial law. Whereas procedural law means what? How this rights can be enforced through a court of law. That is, it sets procedures or regulations wherein how can we put that violation or if the right is being violated, how can it be, what does it put into effect? For a right to violate that, generally what happens? Be it civil or criminal, we approach the court of law, right? So court of law, eppadi approach pandrathu, all those things is mentioned under the procedural law, which is the CPC as well as the CRPC. And in your respective state, be it from Kerala, Tamil Nadu, Andhra Pradesh, wherever you are from, there will be civil rules of practice. And according to those civil rules of practice as well as criminal rules of practice, it lays down different forms in which you have to submit a petition, submit a plaint, a complaint register pannu. It's being mentioned in the criminal rules as well as civil rules of practice. So if you wanted to go into that practice field,
Every day.
One hour. Once again. Yes.
It's a normal thing, sir.
so that is the difference between procedural law and you need to know the difference like in each state order, what is it? Civil rules of practice practice as well as criminal rules of practice. And there are hundreds, 300, 400 sections of rules are there. At a time, if you read, you might not understand. So make a habit of just reading. It is a simple language, layman's term, it is not that big. And they have mentioned the forms in which you have to file a complaint and everything is being mentioned there. So in the 4 subjects, it will be very useful for your future perspective. Now, say for example, your right is being violated. What plus P? Shall we start a civil today? Okay. So a civil right is being violated. Say for example, I have borrowed cars. I have borrowed an amount of say 1 lakh rupees from one person. And while borrowing with money, I have issued a check as security. Okay. Now, what is the remedy? And I say within a period of 6 months, I will pay back the money. Now, what is the remedy available to the creditor who has given me the money if I make a breach in my performance? Anybody? If I make a breach, that is, if I don't give the money as per time, what is the remedy that is being available to the other person? Yes, Abhinesh? Sorry, ma'am. How do you request the other person to give you the money? Huh? Yes? Directly would you file a suit? Then before filing a suit, what is the procedure that has to be adopted? You have to எல்லா கேसेसக்குமே நோட்டீஸ் ஃபைல் பண்ணணும் இல்ல எல்லா கேसेसக்குமே நோட்டீஸ் ஃபைல் பண்ணணும் இல்ல there are mandatory some specific cases you have to file the legal notice and the legal notice. Now who sends the legal notice? Through an advocate we are sending the legal notice. So the first step of starting the intimating the other person or the defaulter that you have made some default and you are entitled to pay such an amount back to my client is the legal notice. That is in the civil side. Now, what happens in the criminal side? What criminal side where accused person about this accusation, how can you first notice every summons is something or summons on so and so day you have to appear before so and so court at a particular time. If you say so, will the accused person will get any notice with regard to this accusation? No, right? So, like legal notice, what is the notice that has been given to an accused in the criminal proceedings? Is it FIR? FIR? We'll go on to the detail, but FIR accused notice கிடையாது. Are you familiar with the concept of charge? Charge is the first notice of accusation given to a accused person. Because when a person is brought before the court, that is by way of warrant, or he appears before the court by way of summons. Summons kodutho illa warrants naleyo or accused person when he appears before the court, now the court will read out the charge to the other person, right? Now charge is enava irukkum section 211 is 211 and 212 has to of CRPC has to be compliant. That deals with the contents of charges. Okay, so what are they to be in the charges is mentioned under 211 and 212. Therein, what is the offence that you have committed? What is the nature of the offence that you have committed? If the offence has a specific name, for example, theft under 378. Actually, then in the charge நம்ம punishment section la mention பண்ணிருக்கோம். Definition section won't be mentioned. What is the punishment section under for theft? 379. And so you are being what is alleged to commit an offence under section 399 of IPC 378 இருக்காது. So the nature of the offence, the name of the offence, the section of the offence. Now suppose if the accused person has any previous conviction. Now what is the necessary of mentioning previous conviction in the charge? Just to know the character of the offender, first of all. Second of all, if the offender is eligible to get enhanced punishment, because subsequent the same type of offences enhanced punishment IPC there are a number of offences. So if it comes under the purview of such a thing, then also it is necessary to include previous conviction. So all those things, and also importantly the place, the against whom, when, and against what property. All those things has to be mentioned as per section 212 of CRPC. So if they allow me detail of only when you give all these things in detail, the accused person will be able to defend himself. Why? Because only then legal notice because you are made a default. Simply you will make a legal notice when the other person will be able to give a reply. You won't be able to give a reply, right? So that in legal notice when you send, every detail has to be furnished. Likewise, when you do a chart, when the court reads and explains to the offender, it has also to be in detail so that the other person can defend. Now moving on to the civil side, how do you draft legal notice? In legal notice, few things have to be there. First one is, very important thing is, the date in which you send a legal notice. Because now to tell you what is the time period or the limitation period for instituting a money suit? 3 years, right? So if you institute a legal notice after the period of 3 years, you will be barred by limitation. That is the mandatory thing in certain circumstances. Not certain, all the legal notice that you send, date is mandatory. So that within that limitation period, that person is acknowledging the debt. You know they are acknowledging the debt, right? Under Section 18 of Limitation Act. So, at the acknowledged part, the time will be portable. So, for that purpose, it is mandatory that you have to mention the date in the legal notice. Then what has to be there? First, the legal notice, I will show you the format, we will discuss in detail and we will move on. Legal notice is the note, first the important thing is the date in which you are sending the legal notice. Next comes against whom you are sending the defaulter. The other person has made the defaulter's name has to be mentioned. Then the subject. Subject has also to be mentioned. Subject means that you are called upon to repay so and so amount of money. Now you have to go into the matter. Now the advocate is actually giving the notice on behalf of his client, right? So on the instructions of my client so and so, detailed descriptions of the client should also be mentioned. And I am sending you the legal notice to you. And in the legal notice also, you need not mention any evidence that you have against the accused defaulter. Now, the check box or this bank slip, all those material things that have to be brought in a trial need not be mentioned in the legal notice. So, legal notice simply means you are intimating to the other person that you have made a default in the payment and you are entitled to give the amount within so and so and you have made a default. So, I call upon you to pay the amount within stipulated like 15 days, 7 days. So, at the time when the failure on which legal proceedings will be initiated against you. If the simple notice is more than enough. And so, first one is date. You need not mention the evidence in the notice. Just the fact that you are giving him a notice of making the payment. More than enough. You need not mention the any evidence in the evidence in the legal notice. Now, once you get the legal notice, in the legal notice there will be a clause that within 7 days or 15 days you have to give the reply or make the payment. Now, what does the opposite party have to do? Send a reply notice. Reply notice advocates or else I can send it to the client of the other person also I can send the legal notice. Now in legal notice another thing, date is also important because we are given 50 days time to reply. So that 50 days reply the date is important. Second scenario is while you give the subject, number already subject and that purpose comes here in the reply notice because you have to mention the reference for which you are giving the reply. That is reference subject clear REF that is reference with regard to the notice sent on so and so date. Okay, then you come to the content. What is the if are you admitting the reply notice could be like any way. You can admit the claim, you can totally deny the claim, you can partially admit, partially deny the claim depending upon your contentions. And it should be signed and sent to the other person. Now, if the other person, that is a defaulter, hasn't made any payment and he hasn't responded or if he hasn't responded to your claim, what is the next step available to the person, aggrieved person? He can institute a suit. He can file a suit before the court. Now, institution of a suit for CPC orders 4, 6, 7, you have to be thorough. And also, framing of suit is very important. Framing of suit under order 1, order 2, all those things are very important when it comes to framing of suit because joint of parties under order 1, framing of suit under order 2, all those and 4, order 4 is institution of a plain suit. Then order 6, pleadings, order 7 with regard to plain, order 8 with regard to written statement. All those things have to be at your fingertips. For office for civil office you should be aware of all those things. Because at stretch number we might not use it, what is it? Explicitly number but explicitly number in that format only we are filing the claim. For example, claims verification, we sign verification, right? All facts stated above are true to the best of my knowledge, belief and information. So, under what rule actually you are doing it? This English custom it is under order 6, rule 15 says about the verification. That is, one second.
Audible. Okay. Yeah.
So the verification is being mentioned under order 6 rule 15. So if only order 16 order 6 rule 15 number verification but it is there in the orders and the CPs. Clear? So if you wanted to draft all these things, all these orders had to be in your fingertips. Clear? Today there's an introduction class and say everything in brief, how our proceedings will be started. Tomorrow onwards we go to the subjects in detail. Now we are playing to file exactly. Now court issue issue then only the factor of issue comes at hand. Now, issue say money you have to know two things. Jurisdiction is very important in two ways. Territorial jurisdiction as well as pecuniary jurisdiction. Right? Territorial jurisdiction that is the place of suing that will determine depend upon the happening of the cause of action. Cause of action depending upon that you can have the place of suing will be different. That is mentioned under section 15 onwards. Section 15 to 22 28. And section 15 to 28 of CPC is the place of suing. So if there is uncertain, if a property rented two or more places எங்க file பண்ணணும் இல்ல uncertain இருக்கு எங்க file பண்ணணும் if it is an immovable property if it is a money suit what is the scenario the defendant is residing somewhere else there are n number of defendants அங்க அப்படி எங்க sue பண்ணணும் all these things are mentioned under section 15 to 20A of CPC. So territorial jurisdiction is important, that is the place within where the cause of action has arisen. Secondly is called the pecuniary jurisdiction. Pecuniary jurisdiction are money limit, which is mentioned under section 6 of CPC. CPC for example, say for example 10,000 lower court jurisdiction up to that you have to within that limits you have to file in the lower court. Higher court is sub court. If it is more than 10 lakh rupees, it can be filed in the sub court. Clear. So these two jurisdictions are very important. And the pecuniary jurisdiction we can ascertain first thing in which court you can file the case. Okay. Now you are about to file the case. Now and also very important is reject circumstances reject you need to know because properly now stamp பண்ணல claim இல்ல நான் undervalue பண்ணிருக்கோம் property worth is 15 lakh rupees அது நம்ம 5 லட்சம் ரூபாய் வச்சிருக்கோம் to evade court fees evade பண்றதுக்கு நம்ம கம்மியா வச்சிருக்கோம் then plain duplicate la file பண்ணலனா there are some certain circumstances has been mentioned under order 7 rule 10 and 11 11 is rejection and 10 is for return of the claim. Those things are also to be kept in mind before filing your case. So you need to know what is the jurisdiction of the court, whether it is pecuniary as well as territorial. Now you have to determine what kind of suit you are going to file, whether it is original petition, original suit, or if it is very family oriented, OPMD, HMA, and also in family also you need to know whether the opposite party, whether the parties belong to which community, religion, Hindu marriage act prakarama, Indian marriage prakarama, Christian or Muslim or special marriage, all those things have to be known only if you know the legislations. Okay, so if it is motor vehicle cases, OP guardian order, all these things, if you wanted to file a suit, you need to know the legislations, right? So please be aware of all the minor acts as well. Now, after that, what is the main important thing? While drafting a claim, before drafting a claim, there are materials that you have to correct. Exactly, address of the opposite party has to be there because you have to send process to the other person, right? The defendant or a correct address. Now, in claim, it is mandatory that you have to furnish the full description of the person. Full descriptions mean what? The name of the person, the age of the opposite party, son or daughter of whom, and the permanent or temporary residing address. These things have to be there. Only then you can identify a person. For example, in the only Balaji, there are a number of Balajis. So, so in order to determine, identify the person, we need to mention the person, the age, the son or daughter of whom, and also the address of the other person have to be there in the plate. Or else we will not be able to send a proper summons to the other person. So proper summons it will not be a due process, right? Or just a trial if there is not be summoned to the other person. Then in plaint also, the another important thing is, while you write a plaint, it should be always be in paragraphs and all the paragraphs have to be numbered. One paragraph, you first one the number, if you are stating about the giving an introduction, giving the who the parties are. Defendant is being so and so, plaintiff is so and so, description good. Next, how they became acquainted. Depending upon your style and your imagination, you can develop your plaint. And comes the cause of action. Cause of action has to be mentioned with date. In the mind that the cause of action has arisen, only then, whether it is barred by limitation or mention we need to know under which date the cause of action has arisen and until which date this may continue. And this another thing, the plainly mentioned which is within the jurisdiction of this court. So So that the pecuniary as well as the territorial jurisdiction among the mentioned particular can be part of the plate. Clear? And what else has to be there? In plate also, you need not tell the evidence. In the plate also, you need not mention what is, I have so evidence, I have like this person to testify on my behalf. We need not mention all these things. Just state the evidence, just state what was the allegation, not allegation, what is our contention, what is the default the other person has done, and cause of action is very important. Next comes the valuation. Suit valuation is also important in order to understand the peculiar jurisdiction. Valuation, as per all states of court fees and suit valuation ಆಗ್ತಿರೋದು and all suit all type of valuation. For injunction it will be different. For money suit, for partition, for anything. There are n number of suits n number types of suit valuation and court fees would be determined for each type of cases. For that you need to know that legislation also. Each state it will be different. And after that, valuation. That is also important. If you are representing as per order 32 prakaram nama or suit file pandrom na, that is on a suit is filed on behalf of a minor, or if you are filing a suit at order 33, if you are seeking as an indigent person. So all these details have to be mentioned. That depending upon the nature of the suit, it will vary from one to another. Then, exactly, the reliefs or the grounds in which you seek relief. Grounds as well as the relief you wanted to claim for. For example, you need the money, or you want to attach the property, or it is an injunction, or whatever relief you wanted, or you want to rescind the contract, or if you want to cancel an instrument. All those things has to be there in the relief. Okay. Now I wanted to discuss in my previous classes. Now if a court has passed a judgment and one of the relief is not being mentioned but or addressed by the court. There are, say for example, I ask 3 or 4 reliefs. Or recovery of money or else we can say it's an movable property. Recovery of movable property or give me the money worth. So car now recover பண்றேன்னா காரோட worth say 1 lakh rupee. அதை நீங்க திரும்ப தாங்க இல்லைன்னா any such reliefs like detention, arrest or attachment of property. This is extra relief if I am asking for. Then suppose the court is not addressing one relief at all. What does it mean? Nariya relief ketirpo. Now all these reliefs have to be addressed by the court, right? The court says that point of determination has to be there. What is the issues? Point of determination and to give a recent decision, blah blah blah, that we learn at order 20. Now, now if the court is not giving any relief to a particular relief, the court is not addressing at all in the judgment. What do you understand from that thing? No relief at all, and it is barred by res judicata. That is section 11, explanation 6 and S. Explanation 5. Explanation 5 of section 11 says about res judicata, wherein if you have asked for a claim and if the court didn't answer to that claim, it means that the court has heard it, adjudicated it, and it is not granting you the relief. So that relief will be barred by res judicata. You cannot sue for that specific relief again. Only remedy available, you can seek for appeal. Okay. Now after say writing the relief, next what you have to write. Now we always keep in mind. Suppose if a plaintiff is seeking the help of a particular document.
Not comfortable. Oh. Okay. I'm not comfortable.
So where was I? No, where was I? No. The other details. What has to be there? After stating the reliefs, is it audible at the back? Is it audible at the back? So what are the, after stating the relief, what has to be mentioned? Suppose if a plaintiff is seeking the help of is totally relying on a particular document and the document is not at his hand, other the opposite party, evidence act section 65 the scenario wherein you can see, you can give secondary evidences. So under section 64, you have to give the what is the primary evidence, whatever available that has to be given. So under section 65, there are scenario circumstances wherein you are entitled to give secondary evidence as well. So in the property, I rely on specific sale deed or a gift deed or a will, which is in the possession of the opposite party. Court case court all these circumstances are section 65 then and my total claim is depending upon the specific specific document. What I should do? For the time being, while I file the claims, I should file the certified copy. Photo start file but photostats won't be taken into evidence. So at the time of trial, you have to file the certified copy itself. So while you file the claims, you have to give the list of documents that on which you rely, starting with the legal notice. Legal notice the reply notice. The reply notice the other notice. Legal notice alone, then if it's any documents that you rely on, other prior deeds, where the conflicts are, all those deeds should be also attached along with the plain value file itself. So, if a plaintiff is totally relying on a specific document, all those documents also have to be filed along with the plaintiff. Okay? And after the list of documents, what has to be mentioned? Verification. The sign of the advocates, then comes the verification. That is, all facts stated above are true to the best of my knowledge, belief and information. And it shall be signed by the deponent. Okay? And also this plain should be accompanied by filed in duplicate and it should be accompanied by an affidavit also. Affidavit to say the file. If suppose there are five people, 5 plaintiffs are affidavit shall be filed on behalf of one person. Like all the 5 of the file on behalf of all the person, even one person can file the affidavit. But when you file the claim, each paper of the claim has to be signed by each plaintiff. Every plaintiff, even if it is 1500, all the plaintiffs have to sign in each of the claims. Affidavit need not be. Affidavit on behalf of all the person, one person can also file. Now suppose if the claim is not filed in duplicate, what will happen? Will it be returned or rejected? Returned or rejected? Yes, sir, will it be returned or rejected? Returned or rejected? No. If it is not filed in duplicate, will it be returned or rejected? Rejected under Order 7, Rule 11. Clear? It will be rejected. That is, you have to file with duplicate, other report. No, to both are different. But it is different. Clear so far? So this is how you file a plain. That is by plain. I also main thing. Plain is filed under which order? Under depending upon the territorial jurisdiction or peculiar jurisdiction, we are asserting. Before the Honorable so and so court, so and so place. Before the Honorable Municipal Court, Tripoli, or Civil Junior Court. What do you say here? Junior Civil Judges Court, Tripoli. Next comes what? We have to state what kind of case it is. OS number, OP number, whatever it is. OS number dash of 2024. Then parties. Details of the parties. That is, now you need not specifically tell the full details. Full details. Instead, you have to write the plaintiff 1, 2, 3, 4. Defendant 1, 2, 3, 4. How many numbers are there? All the numbers has to be there. Now, after that, small cost title. Plain filed under section 26, read with order 7, rule 1 of Code of Civil Procedure. If it is any special, where a special act file that special law has to be mentioned. If it is family code or the family code or jurisdiction in the section all those things has to be mentioned. Then plaintiff edited, no plaintiff, each plaintiff's detailed description has to be there. That is, plaintiff number 1, Mr. X, son of so and so, age so and so, residing at so and so. All those things. Now each plaintiff numbers has to be mentioned. Now after that, all processes, notices shall be sent to the above plaintiff in the above sent address or to the advocate that has been engaged. Same goes with the defendant as well. Now defendant, D1, 2, 3, how many defendants are there? All the defendants' details has to be there. Full details must be mentioned. And likewise, our parent details, address, and all processes notices of the defendant shall be sent to the above said address or to the counsel if he may engage. Now, next, what is the step? The plaintiff humbly submits as follows, and he goes to the faction of the case. Facts and please keep in mind, all the facts must be in paragraph and it must be numbered. Then, and allegation and cause of action, and I'll give you a format, I'll give you a demo of the next class so that you can understand how it is to be done. And as we have stated, cause of action, whether it is within the territorial jurisdiction, and with the peculiar jurisdiction, it will only with the valuation. Valuation of peculiar jurisdiction would be here, and the relief. This is the format for a written statement. Now, once the written statement is being filed, copies, say for example, there are 5 defendants are there. 5 defendants who copy number which is 5 copies of the plain must be submitted along while filing the plain also. Now, within how many days you have to send summons to the defendant? Actually, it is 30 days. 30 days summons are. Now, once the defendant has received these summons, or he has gotten the summons, he is appearing before the court. Now, once he appears before the court, the defendants, any one of the defendants or all the defendants has appeared before the court, within how many days are they entitled to file the written statement? Within 30 days on the date on which the defendant has appeared, has to file the written statement. Right? Now, in Order 8, Rule 1 itself, they have it is mentioned that even after the expiry of 30 days, another 30 days, which is a total of 90 days, is available under Order 8, Rule 1, where the defendant can file a written statement. Understood? First 30 days, he has appeared before the court, and from that day till 30 days, he has time to file the written statement. Now, if he fails to file within the 30 days, another 30 days, or in total of 60 days from the date of entering appearance, he has a time period to file the written statement. Now, apart from this, apart from Order 8, Rule 1 limitation, you can also seek help under You can also see help under CPC itself under section 151. What does section 151 says? Inherent powers of the civil code. Civil codes means like all the civil codes. Whereas inherent powers of the criminal codes, only High Court has the criminal power under section 482 CRPC. Number only 482 CRPC says about inherent power of the High Courts. Whereas under section 151 of CPC, it says about the inherent powers of all the civil courts, irrespective of this hierarchy. Civil, junior court, junior civil judge courts, sub courts, district courts, and the court, all the court has inherent powers under section 151. Now, what do you mean by inherent power? In CPC, there are no rules, so limited to the CPC, whatever rules or the sections, and the court can have an extra power. It's an extra power to the civil courts. Now, even after seeking time under 151, another way also you can seek extension of time. Section 148 of CPC says enlargement of time. Wherever under CPC, time period specified panirukanga, you can seek enlargement of time under section 148 CPC for the extension of time maximum of 30 days. Maximum of 30 days you can seek enlargement of time under section 148. So these are some tips that you can use while you practice. So once the person has appeared for a period of 30 days, within a period of 30 days you have to file the written statement. Another period of 60 days, 30 days in total of 60 days. Even after the expiry of that, you need some time to file the written statement, sufficient time. But you have to prove that there is sufficient cause for not filing the written statement within the stipulated time period. And that is under section 151 as well as section 148 of CPC, you can see the time. Now, under what order you are filing written statement? Order A, rule 1 of same code goes with the drafting the written statement as well. Okay, the written statement, for the title of the court, OS number, by the time the number OS will be numbered, number of the case, plaintiff, defendant. Written statement, under the detailed description of the plaintiff, defendant, it is already been mentioned under the plaintiff. So written statement just to mention the plaintiff and the defendant. And also, we have to write a small cause title. Written statement filed on behalf of the defendants. Over defendants, over counsel government, defendant D1, or on behalf of all the defendants under order 8, rule 1 of CPC. Now the written statement humbly submitted by the defendants. And also, now, in written statement, it is very important. First defense before the trial itself, your first defense starts with the written statement itself. When this claim has already been numbered, why it is being numbered is because for the defendant to either to admit or to deny the arguments claimed in the plaintiff. Say for example, the arguments mentioned in claim number, paragraph number 1, 2, 3 is admitted by the defendant. Maybe our partition first 3 paragraphs, they are siblings, that they inherited the property by so and so. After the basic argument, which the defendant is also admitting, then you can say paragraph numbers 1 to 3 of the written statement is admitted by the defendant. Now, in written statement also, it is mandatory that you have to either admit or deny. Specifically, you have to admit or deny the facts. Or else you should not evasively, the paragraphs 1 to 3 is being admitted, paragraph 1 to 3 is denied. Evasively, you shouldn't admit or deny. That will be done in formal objections. If you wanted to claim the defense, then you have to specifically deny. Or if there is any new thing factor which is not mentioned in the other, for example, say the second bill, the second bill stands right, Allegiance Succession Act. So second bill is in my favor, and the bill particular details has to be mentioned specifically. Always your defense should be not evasive, must be specific. And what all things has to be mentioned? In Written statement also, you should not mention any evidences. Evidences need not be stated in written statement also. That can be mentioned only in the trial. And in written statement also, if the person is seeking the help of any documents, all those documents has to be mentioned in list of documents and it should be produced with copy while we submitting the written statement. Copies must be served to the other parties as well. And same verification, all those things as the same as in the plain. Clear? Clear so far? Now, you know the difference between what is the other than written statements? பின்னாடி இருக்கிறவங்க கொஞ்சம் அமைதியா இருக்கீங்களா? Other than written statement we know it is by way of defense, right? This is our first defense we are stating. Other than the written statement, what all can be the defenses? What all ways in which you can seek for defenses? Set off or counterclaim. Under Order 8, Rule 6 and Order 8, Rule 6A of CPC says about set off and counterclaim respectively. Set off means what? Set off can be claimed only in a money suit. ஒரு money decree இருக்கும்போது that money decree ஒரு money claim இருக்கும்போது and that money should be a certain sum of money. It shouldn't be an unliquidated damages like ஒரு defamation இருக்கிறதோ இல்லைன்னா ஒரு motor vehicle கேஸ்ல நம்ம கோர்ட் நம்ம grant பண்ற விஷயம் may not grant the remedy that we seek for. If I am met with an accident or if you detain me, I might give the relief of 50 crore or 100 crores, but the court will give me 50,000. So this is unliquidated damages. Such unliquidated damages cannot be set off. Only in set off it should be certain sum of money, and also it should be in a money suit. And if you seek the help, if you wanted to get the set off, you should be admitting the claims of the other party. You guys know the concept of set off, right? So no need to explain it. And moving on, it is the counterclaim. Counterclaim it is like a cross suit. It has its own status of that of a claim. Now, counterclaim file பண்றது order 8 rule 60 பிரகாரம் நம்ம counterclaim file பண்ணும்போது it should be in such a way that you draft the plaint itself. Even if the plaintiff is the original suit is being dismissed and the defendant is appearing, you know the circumstances in which a plaint can be dismissed, right? Order 9, Rule 2, 3, 5 and 8 of CPC says circumstances wherein a suit can be said to be dismissed. So in all these circumstances, if the suit is being dismissed and the defendant is appearing before the court, now this suit can be, even the counterclaim can be treated as a suit. Okay, clear? And so in a counterclaim also you have to mention the details as if like suit valuation or all the details, all the things has to be mentioned in counterclaim as well. Clear? I know people are being restless, but bear with me for time on this. Now, what are the other type of remedies that are been available under CPC? There are supplementary proceedings, right? What do you mean supplementary proceedings? Under section 94 CPC? Like injunction, like arrest and detention before judgment, attachment before judgment, appointment of a receiver, then incidental proceedings under orders 26, appointment of a commissioner. All those things can also be, we can seek remedy under these things. So under order 38, rule 1 to 4, order 38, 5 to 13, says about arrest and detention before judgment as well as attachment before judgment. Please do read this rule. Order 38 as well as order 39, injunction. What are remedies you can seek injunction? These are very important. Okay, while if you wanted to practice in the civil side, this is very important. Then in order, all these orders they have given you instances wherein you can see even for money suit also. Even in money suit also you can see you can find the petition under order 30 rule 5. Attachment of defaulters property. All those things are mentioned under order 30 rule 5 to 30. Then moving on, once a decree is being passed and the other person hasn't acted upon the decree, what is the remedy again available to you? Execution petition. You can file execution under Order 21. Order 21, there are 106 rules and section 36 to section 73, I guess, deals with execution under the CPC sections. So orders 106 of Order 21, Rule 1 to 106 deals with execution of a petition. Now, execution is also two types, right? You can make oral as well as written submission, written application. Now, all application filed under circumstances are now Order 21, Rule 10 of CPC says you can file oral application. Oral application can be made in one particular type of case only and in one particular circumstance only. That is, only in money suit you can file an oral application. That is, the court is pronouncing the judgment or the decree right now. In the court, the decree holder is liable to pay 1 lakh rupees to the the JD is liable to pay 1 lakh rupees to the decree holder. Suppose if the JD or the judgment debtor is within the presence of the court and it is a money suit, only in these two circumstances the court can allow oral application. Then and there the person would be arrested and you can seek the remedy, or if he pays the money then I think he will be released. That is Order 21 Rule 10. Whereas Order 21 Rule 11 says about written application. Okay. Written application original case number, who are the parties, what was the decree, and all those details has to be mentioned, and who has to pay, and if there is any attachment. If the property is already been attached to the original suit, that need not be reattached in the applications. Reattached control table is mentioned in Order 38. So please go through all these things. I think we will have the next class. Thank you for cooperating. Lock the door. Manner. Follow my instruction, that's all. days మిమ్మల్ని బంధించేస్తాం. బందీఖానా. You are not allowed to. ఏంటి? బ్యాగ్ నెత్తి కింద పెట్టు. ట్రైన్లో కూర్చుంటున్నాం. ఫస్ట్ నేనే తిట్లో తినాలన్నమాట.
ఇది అడ్జస్ట్ చేయి మేడం కాలేదండి. కాలు తగిలిపోయింది. అవునా? 2 rooms full. Okay, done.
Yes. Yes, the last benches. Quick. Occupy your seat. Occupy your seats. Quick. Thank you. Sharma, close చేసే the door. వెళ్ళుకొని క్లోజ్ చేసే. Yes. In continuation of our earlier classes, today I will start the duties, which is very important for your exam. No photos. You are not permitted to take photo. Who opened the door? దీంట్లో టైం అయిపోతుంది. Lock it. Ma. Yes. Code of conduct and ethics. This is very important subject, and the second part of this auditorium has to concentrate because you need more. You need more of this lecture. The second part of the auditorium. What do you mean by ethics? What do you mean by a code of conduct? Principles? A person supposed to follow. Very good. A set of rules. A person, a professional has to follow. You being a law student has set of rules to abide by. Agree? You are a law student. You being a student of law has to abide by certain rules. If you fail to observe, it leads to what? It leads to misconduct. Misconduct. You will be charged with misconduct. The same principle you have to apply to other professions also. To everyone. Each and every profession has certain rules of conduct, ethics, and that must be observed by them. So all those rules here are discussed as duties. If you perform your duty, then only you can raise your voice against your right. Agree to this? So, ముందు మా right నడకుండా, you have to introspect whether you have performed your duty to the fullest. If you fail to perform the duty, these duties are multi-sphere, and if you fail to observe this, that leads to misconduct. That leads to professional misconduct. So once you enter your profession, from day one of your profession, you have to keep in mind all the duties which are set forth by the Bar Council of India. The Bar Council. It is the authority to frame rules. And so, in this lecture we will be seeing the duties of an advocate, your future advocates. Remember, so what are your duties? Duty towards the court. We will be seeing all the duties one by one. Duty towards the court. And what are the duties that lie towards your client? Next, duty towards the opposite party, opponent. Duty towards your colleagues, your colleague friends, other advocates. You may have a tug of war in the court hall. You may have a tug of war in the court hall with respect to a particular case, with respect to a particular party issue. But once you come out of the court hall, you should forget what are all the arguments you had. No personal arguments arise in the court hall. Arguments arise only with regard to a case and then and there itself. Once you come out of court hall, all the arguments have to come down. So what are the duties towards your colleague? And the other general duties you need to observe. This is very important. Concentrate. So, with just one statement, you can understand the duties of an advocate clearly. What is that statement? Can the second part of auditorium see the slide? Is it clear? Yes. Please let me know if not. I will make necessary changes from next class. And so, Justice Marshall observed the fundamental aim of legal ethics is to maintain honor and dignity of the law profession. Is to maintain honor and dignity of law profession. To secure a spirit of friendly relationship, friendly cooperation between the bench and the bar. Who is bench? Evarni bench antam, bar evarni antaru. Bar ante ikkada, court bar. Vere edo kaadu. What is bar and what is bench? Judges ఏమంటారు? బెంచ్ అంటామా, బార్ అంటారా? Advocates వీళ్ళని. Next, to establish honorable and fair dealings of the counsel with his client, opponent and witnesses, to establish a spirit of brotherhood in bar itself. Spirit of brotherhood. That is the duty towards your colleagues, duty towards your client, duty towards your opponent. And duty towards your court. So the ultimate duty lies with an advocate. If you observe all the duties properly, then there is no question of misconduct. There is no question of interference by the disciplinary committee of bar, etc., etc. And so, we will see what are the duties towards the court. Rule 1 to 10 of Advocates Act, Bar Council. It lays down certain rules. Imagine you are an advocate. You are an advocate. What is your duty to perform? How you need to behave in a court. How you need to behave with the judges. Duty towards the court. While discussing duty towards a client, imagine you are a client. You are a client, you are not an advocate here. You have to change your role. Imagine you are a client and what you expect from your advocate. And so, the duty of an advocate comes. Getting my point? Yes. Then, while discussing duty towards the opponent, here you change the role to your status of an opponent or opposite party, and what do you expect from the advocate, the other advocate? So you have to imagine, you have to presume yourself as that particular party. అప్పుడే మీ యొక్క రైట్ ఏమేమి తెలుస్తుంది, అదర్ సైడ్ యొక్క డ్యూటీ ఏమేమి హైలైట్ అవుతుంది. ఇట్స్ వెరీ జనరల్ థింగ్స్. You need not use your brain much except the last rows. Last row. Remember, you will be marked absent.
నాకు దయాదాక్షిణ్యం కొంచెం కూడా లేదు. I don't show mercy on you people, especially the last rows and all. Remember. And coming to the duties one by one. Number one, it is the duty of an advocate to show due respect to the court. Yes or no? So, that shows your professional conduct. It's not misconduct, professional conduct. If you are a professional, if you want to be treated as a professional, then you should follow certain guidelines. Conduct. You should respect the court, the judge. And what other duty? You can just answer because this is a very general topic. Can you influence, as an advocate, can you influence the judge? Can you try to influence a judge to get a favorable order? What happens if you influence? It amounts to misconduct. And then, give some more examples. Debarred from the bar. Okay, that is a punishment. Threaten. Okay, threatening the opponent. Compromise. They don't get compromised, they get colluded. Colluded అయిపోతారు advocates. మధ్యలో క్లయింట్ గోవిందా. Very frequently, 80% of the advocates in near place, they are doing this. They are actually involved in this act of collusion. Advocates are colluding. That is the misconduct. కానీ బయటకు వస్తుందా? No. It's happening and even the court will not take cognizance of it slow motor. లేదు. And advocate shall not communicate privately. Private chambers వెళ్ళి కలవకూడదు. Advocate shall not meet the judge. Shall not. It's not permitted. Next, shall always be punctual in attending courts. If you are punctual in attending classes, then you get habituated to attend courts on time. Shall not include any fact which he knows to be false in either the pleadings or petitions or affidavits. What does this mean? Sir, what does this mean? Shall not include any fact which he knows to be false. Advocate knows very well that that is a false statement. And he cannot mislead. He cannot make any misrepresentations, either in the petition or affidavit. Next, he shall not ask for adjournment of case unless there is a valid reason, unless there is a sufficient reason. There are advocates who are known for adjournments. Case నడపనివ్వరు ముందుకి, వాయిదా తీసుకుంటూనే ఉంటారు. There are advocates. So that affects the integrity of the profession. Avuna? Discipline ledu. So can that advocate be referred by anyone in future? No. Stamp padipotundi. He is known for adjournments. If there are litigants who want to take adjournments, only those approach the advocates. Oh no. And next, advocate shall not speak ill of judges or use abusive marks. This one point you have started observing while writing part C in your exam. Case comment. While writing case comment, I guess I told you, I advised you how to write the last part. Instead of writing suggestions or conclusion, you have to write a comment. You are commenting on that particular case. So while commenting, you should not use very abusive language which deteriorates the status of a judge, the one who has passed the judgment. And the comments must be very positively. Even if you want to criticize it in a very positive way. And next, advocate shall not interrupt when the counsel for the other side or the judge is speaking. We are all studying all the duties according to the rules that are framed. And the question at the end comes whether all the duties are observing by the advocates. Whether all the duties are fulfilled. While studying, while reading to each and every duty, we find a violation of the duty in practice. Avuna? Avunu. So, where comes the deficiency? We are not supposed to, but we are doing. An advocate shall not practice before a judge if he is related to him. Relative, judge relative aite, a person that is the advocate shall not represent the case because there can be a presumption of bias. Bias anedi jarugutundi, giving a chance to the opposite party. Even if judge and an advocate acts fairly, the other party, the opponent, comes to a decision, he judges that he gets a favorable order because he is related. There comes the question of bias. Again, Mali. And next, shall not act or plead in any matter in which he has a pecuniary interest. What do you mean by pecuniary interest? Monetary interest. An advocate shall not appear for any organization, institution or society if he is a member of an executive committee. If he is a member of an executive committee, then he cannot plead on behalf of that particular organization or an institution or a society. Why? Why? Bias, ఏం bias? He is a party. He is playing the role of a party to the case. పార్టీగా ఉన్నారు, అడ్వకేట్ గా ఎట్లా రిప్రజెంట్ చేసుకుంటాడు? He is a member of the committee. And so, he shall not. If he violates any of these rules, then that amounts to professional misconduct. These 10 points, see, I have highlighted only most relevant factors, most relevant duties of an advocate towards the court. That's all. And next we will see the duty towards client. Duty towards the client. Now presume you are a client. What do you expect from your advocate? You are paying him fee. Remember, You are paying him fee. So what do you expect from him? You expect transparency. Yes? You expect what? You expect to maintain secrecy of information. Okay, not to disclose to the opposite party so that they may take advantage of your situation. Okay, next. Okay, collusion. Duty not to pollute with the opposite. You expect it. Good. Next. Speedy trial. Yes. Duty to act. Okay, duty to render justice. Justice to your client. Even if he is wrong. Yes. Yes. Even if your client is at wrong, you have to defend him. You have to win. Remember, winning or losing ultimately depends on how best you plead, how best you convince the judge. Convince here means not meeting him personally in the private chambers, nothing. You have to convince him with your skills, argumentative skills and drafting skill. Drafting అంత సింపుల్ కాదు. ఇప్పుడైతే అన్నీ ఒక స్టాండర్డ్ ఫార్మ్ ఆఫ్ కాంట్రాక్ట్ లాగా వచ్చేసింది. ఎవ్రీథింగ్ ఇస్ స్టాండర్డ్. డీల్ కావాలి అంటే దే టేక్ ద ప్రింట్స్ అండ్ ఓన్లీ ద పార్టీస్ address and other details are changed, that's all, nothing else. Prior to this computerization, they used to draft. If you get a chance to read the old records, handwritten records, deeds and all, you please read. And you get a difference between the present and the past. And duty towards the client, only I got only three, four duties from you. Any other? You don't expect anything other than this four, huh? You are paying fee and your advocate is accountable for the fee, right? Whenever you demand, he has to show accounts for which how much amount he has spent. Will you permit your advocate to misappropriate the fund? No. Suppose there comes a situation where the client asks for return of kata ichese nenu velipotanu. I don't trust you. I lost trust on you. You please return all the files and documents. Then is it not the duty of the advocate to return? Can he threaten you with some more money or demand you? Chances. What if the situation arises? Imagine you are a client. So if that situation arises, then what is the remedy you have? Will you make a complaint to the authority or will you pay the amount which he demanded? Authority. You take this to the notice of authorities and make disciplinary actions and all. Okay. So, పక్కాగా ఉన్నారు మొత్తానికి. So an advocate is bound to accept a case. He is bound to accept a case, which means he also has a right to reject a case. He has a right to reject a case. Here the duty is he has to accept a case. To what extent this duty lies? Whether it is an absolute duty or do he have any right to reject the case also? He has the right to reject. So నేను ఈ కట్ట తీసుకోను అంటే ఇది మీ ప్రొఫెషనల్ మిస్కాండక్ట్, నీ పైన కంప్లైంట్ ఇస్తానంటే ఒప్పుకుంటారా? చేసుకో, ఎవరు చేసుకుంటావు చేసుకోపో అంటారు. because an advocate is not interested. While before accepting a case, he must have a thorough knowledge of the case, brief తెలియాలి, ఏం issues ఏంటి తెలియాలి, and he should be in a position to analyze. He must be in a position to judge whether there are chances of winning or losing is more. There are a point arises where he loses the case. So in that situation, a client, you here in this example, cannot charge him for his deficiency. Whether an customer relationship exists between an advocate and client, whether a client is considered a customer. In case of deficiency of service by a legal professional, can a client sue him in consumer forum? Is he a customer? Is he a consumer? A client is a consumer. So if he is a consumer, then consumer forum is available to him. In defective services, let me know some instances of defective services. Tampering, very good. Okay. Gross negligence. Gross negligence in the sense? Intentionally. Okay, intention plays there. Next. అదే మనకి హాహా ఓహో అని కొల్యూషన్ జరుగుతుంది పక్క ఊర్లోనే, ఎక్కడో కూడా కాదు. యాక్టింగ్ ఫర్ ది అదర్ సైడ్, హీ జంప్స్ ద సైడ్. మళ్ళీ సో ఇన్ ఆల్ దీస్ కేసెస్ క్యాన్ ఏ కన్స్యూమర్ టేక్ రీకోర్స్ టు కన్స్యూమర్ ఫోరం? కన్స్యూమర్ ప్రొటెక్షన్ యాక్ట్ కింద అతనికి రిలీఫ్ ఉంటుందా ఉండదా ఈజ్ మై క్వశ్చన్. No. Just now you said yes. You are jumping here. According to professional misconduct? Okay. He cannot be tried. So advocate cannot be tried under Consumer Protection Act. That is the punishment. Is Consumer Protection Act is available to the client. As supplemental remedy ga emana unda, or here there is no scope for consumer protection. Basically client is not a consumer and so cannot take recourse to consumer protection another na question, because we have tilting decisions. Yes, consumer, that is client can be considered as a consumer. No. Okay,
Because it's not trade.
It's not trade, but you are paying fee. Who is a consumer then? Paying something, and for that you are getting something. Advocate renders service for the payment which he received. Okay, and so now tell me whether you are a consumer or just a client in the eyes of law. That's all. We have lot of time. Inka 10 days on kusti padala. You can answer me tomorrow also. Sharma ledu. Not a consumer. So
But as far as I know, the client will never be called as consumer because amount
if you are comparing, taking into consideration the fee, a matter of fee, and in Consumer Protection Act, it is price of a good. And then comparison, you are making comparison with price and fee. Okay. A business or a trade. I'll tell you, I'll give you just an example. Listen, an advocate is bound to inform his client regarding the next adjournment, next date of appearance or whatsoever. Okay? If he failed to inform and as a consequence, he didn't appear to the court. Rani ledu court ki. Present avalli raledu. Reverse lo vachindi order because of his absence. Now, who is liable? Will an advocate compensate the loss? No? Yes? Who said yes? That's what I'm saying. Husband, family law, చెప్పి husband wife వస్తుంది నోట్లో. Okay, so in such situation, whether an advocate is or whether an advocate can be tried for deficiency of service under Consumer Protection Act. We'll see. Why? He is the one who is representing the client. He is duty bound to. We will discuss this one particular matter whenever time permits. Whenever time permits, please. Refer cheyandi time unnindante. Whether he can be brought under the category of customer, consumer, whether an advocate can be tried for deficiency of service under Consumer Protection Act. Only these two questions I have for you, and anyone can come with an answer. It is generally for everyone, but those who have interest can refer and come. And next, he shall not refuse to appear for an accused. He shall not refuse to appear for an accused merely because in his personal opinion, here personal opinion do not have any role to play. Even for an advocate and a judge, their personal opinion has to keep aside. Only basing on the facts, issues, the case has to be tried. So, అతను నిజంగానే చేసి ఉంటాడేమో, అఫెన్స్ చేసి ఉంటాడేమో, కమిట్ చేసి ఉంటాడనే ఒక ఒపీనియన్తో he should not refuse a client. He cannot refuse an accused person. He cannot refuse to plead on behalf of an accused person, deeming that he has committed the crime. He has committed an offense. Only if it is proved, only if the guilt is proved, he is otherwise acquitted, right? And next, he shall not. Point 5 is very important. Point 5 is very important and it comes for part C. What is this point? The one you told. Non-disclosure. He should not disclose. As an advocate, you are bound to maintain secrecy of all the information because trust plays a very vital role. In our previous classes, we have seen the lamps of advocacy. Lamps of advocacy. So, only if your client has faith in you, he will disclose all the facts, అతను తప్పు ఉన్నా కూడా అది మీకు చెప్తారు, బికాస్ యు ఆర్ గోయింగ్ టు సేవ్ హిమ్. And so you cannot, an advocate cannot break that trust. An advocate shall not disclose any matter relating to that particular case to anybody, especially the opposite party. Next, he shall not buy or agree to share the interest of the litigation. Disputed ఏదైనా ఉంది అంటే దాన్ని నేను కొనుక్కుంటాను, దానికి ఇంత ఇచ్చేస్తాను అని ముందే వాళ్ళు అవ్వకూడదు. He should not. That's what I told you. All the duties which are mentioned under the authority, by the authority, are in grave violation. Best example, strike. Strike. మొన్న నార్మల్ సీక్ వచ్చింది తిరుపతి ఏరియాలో రిలేటింగ్ టు దట్ ల్యాండ్ టైటిల్ యాక్ట్. He should maintain separate accounts for the 8th point. Okay. He shall not directly or indirectly bid or purchase the property in his own name or in the name of any other person. నా పేరుతో లేదు, మా ఇంట్లో వాళ్ళ పేరుతో ప్రాపర్టీ తీసుకున్నాను అంటే దట్స్ వాట్ హ్యాపెనింగ్. It's against the rule, against the conduct, the rule set by. Continue. You want to? Next is yours. Twelve now. 2 more minutes. సిగ్గులేదు ఏం జన్మమో. See, you have come to the last semester. திட்டு வாங்காம காலேஜ் விட்டு போங்க. நல்லபடியா ஒரு குட் பர்சனா ஒரு டீச்சர்ல பேட் கான்டக்ட் இல்லாம போங்க. அதுவே ஒரு பெரிய சர்டிபிகேட் உங்களுக்கு. And next comes a copy of client's account shall be furnished to him on demand. Whenever client demands, an advocate has to keep ready the accounts for which he has spent. Whatever the money he received from the client has to be maintained in a book of record. Starting from filing of wakalat. దానికి ముందు అడ్వైజ్ ఇచ్చింది, దానికి లీగల్ అడ్వైజ్, లీగల్ ఒపీనియన్ వస్తారు కదా, అప్పటి నుంచి ఏమేమి చేస్తున్నారో టిల్ ద డిగ్రీ ఇస్ పాస్డ్. డిగ్రీ పాస్ చేసిన తర్వాత నెక్స్ట్ స్టెప్ ఏంటి? ఎగ్జిక్యూషన్. అవునా? ఈపీ ఆర్డర్తో అవ్వదు, ఈపీ చేసుకోవాలి, ఫైల్ చేయాలి. అంతవరకు మీరు ఏమేమి స్పెండ్ చేస్తున్నారో ఎవ్రీథింగ్ హ్యాస్ టు బి మెయింటైన్డ్ ప్రాపర్లీ, బికాస్ యూ హ్యావ్ టు ప్రొటెక్ట్ యువర్ ఓన్ స్కిన్. Later on you cannot be challenged by your client, okay, for misappropriation of funds. And he, that is an advocate who has advised or prepared the pleadings or appeared for a party in any suit or appeal, shall not act, appear or plead for the opposite party. This is what you told me few minutes back. Jump. At one point of time, at one stage, you plead on behalf of a client, your client, and some dispute or rupture arises between you and your client, and he has taken back all the case related documents and all everything, and he approached the other advocate, your friend. Now, you cannot help the opposite party, opposite advocate. నా దగ్గర నుంచి వెళ్ళిపోయినాడు కదా, అతనికి ఎట్లయినా నేను బుద్ధి చెప్పాలి అని మీరు వాళ్ళతో కొల్యూడ్ అయ్యి యూ కెన్ నాట్. That is not your professional code of conduct. That makes you an unprofessional. That's all. Simple ga cheppalante unprofessional. Misconduct kuda undi. Okay? So these are all the duties towards the client. And in next class, I will be discussing the other duties, like duties towards the opponent, opposite party, duty towards your colleagues, and the other relevant duties. Okay? If time permits, go through all the 3 duties and come prepared, because we can have a discussion. Instead of having one-way teaching, this topic, this chapter has to be discussed 2 ways. And I will be discussing, and you can tell me the different instances of professional misconduct.
Just you put an announcement or you put lady come. How do you put it?
Dear students, sorry for interruption because you are, since morning onwards, you are continuously listening the special lecture program which we have arranged for you. Here is drink water. Insufficient of water in your body. So, here is an important announcement for you. Kindly note down. Silence please. Maintain high silence because we believe in discipline. First of all, every day whenever you are coming, we will collect your signature, your attendance, means your attendance here only. But in auditorium, 3 years general and honors. Students, please wait here after completion of your class, 4th hour, after penology and victimology. Please wait here. This auditorium, in auditorium, we will take the attendance of 3 years general and honors. Okay? 5 years BA LL.B general students. You have to occupy your seat for attendance in 4th floor, room number 1. 5 years general students, BA LL.B general students. 4th floor, room number 1. Honor students, room number 2. The same floor, 4th floor, room number 2. 5 years BA LL.B honors. BBA students, room number 3. 4th floor, room number 3. Please note down, don't forget, don't get any confusion. If you lose your chance, this signature, automatically, immediately, it will show absent. Though you are present here today, but it will mark as an absent. And you know, if one day also you will absent, what will happen after completion of this examination. Don't forget to sign in attendance sheet, which we will give after the completion of fourth class. And become students, 4th floor, room number 4. After class, you kindly go there, maintain discipline, give your attendance there and go. Second important point, second important things, afternoon there is no class for general students. Afternoon only honor students will assemble here. Afternoon, for general students there is no class. Okay. Second, next one is regarding court visit. We got the permission from the Honorable Court. They allowed us to send the students for court observation. Today and tomorrow. Today and tomorrow you will attend here. Day after tomorrow onwards, that means 20th onwards, you will attend the court. And that is also group wise, not all students. We will announce. Tomorrow you will get all details information regarding your court visit. Details information. The group wise students will go and they will observe the court proceedings. They will maintain that records. Not all students. So during that time, one group students will go there and other rest of the students will attend classes here. Morning one group, afternoon one group. Rest of the time you will attend classes here. Clear? Is it clear? Okay, so don't forget that. Group wise we will give you details information, the registration number from this registration number to that registration number, they will attend that group. If your registration number is not there, don't go there. If you go there, here your present will be absent, marked as an absent. So tomorrow you will get all this clear picture about your court visit. And inside the court, last time what we observed, so the 4 or 5 students, we did not allow them to write examination due to their misconduct. We received that complaint from the court that during their visit, court proceeding, they took selfie with advocates. We are sending them to learn something, not to take selfie and post it immediately in your Facebook to inform the other parts of the world that today you are attending court proceedings, that observing court proceedings. Don't do that. Photography is strictly prohibited inside the court. Please remember, if you get any complaint against anyone, you will be debarred to write examination. Kindly note down. Kindly mark my words. This is very strictly we are, because we are getting the remarks from the court. That's why the court is not allowing the students. They are not behaving properly. You are going there to learn something. Kindly make use of your valuable time. Don't waste your valuable time there. Try to learn that. Don't take selfie. Don't take photograph. Second thing, with regard to court visit, parking your vehicle. Vehicles are strictly prohibited. As the bar members, they have their own vehicle. They are parking. They have every right to park their vehicle inside the court premises. But for students, don't take your vehicle there. Due to the shortage of parking place, and some of the students, they are parking the bike also, they are parking here and there, and they are immediately going to court. So last time we received the complaint with regard to that also. So if vehicles are not allowed, if you are taking their vehicles at your own risk, don't keep there. If they will inform police and police will take your bike, then risk is yours, responsibility is yours. Don't blame. So before that, that's why I am here announcing, don't take your vehicle there, don't park your vehicle here and there. Bike only because we'll send there, bikes only allowed, but find out a suitable place for your parking. Don't park here and there. We are strictly, we are not allowing to take your bike and vehicle there. We are receiving the bad remarks from the court, the bar members. They are objecting. Okay. Next, that is the with regard to that, and the important is today we observed that so many students they came after 9:30. Every day your class will start here from 9:30 onwards. Try to reach before that. Today first day, that's why we consider your problem. So tomorrow onwards kindly try to reach here at 9:30. Before 9:30 kindly occupy this seat. Kindly occupy this seat. Okay? To avoid the last moment indiscipline. And as I told you that we believe in the discipline. So if we found any indiscipline or misbehavior of students, will not allow, the management has taken these decisions, will not allow to submit your examination application form, because we believe in discipline. Okay, please remember, tomorrow you will get all the information regarding your court visit. With this, let me stop here, and with this I would like to invite my esteemed colleagues, Professor Subhamastu Pandar, to take this class, Penology and Victimology. He will discuss. So these two parts, Penology and Victimology, Sir will deal with Penology part, and I will, after the completion of his portions, we will discuss. I will discuss from the Victimology. Okay? So, Subhamastu sir, please come and continue your class. Thank you, dear students.
Good afternoon, everyone. So today our topic is penology. So first thing first, when we enter to some subjects, we need to know about that what is the meaning of that particular word. So according to you, what is the meaning of penology? Study of penal provision. That means punishment. So first thing comes to our mind that why we are going to get the punishment, or why there is need of punishment. Why? Yes, to create fear. But for why? Why we need to create fear on someone else's mind? To stop the crime. So, yes. So that is our topic today. What is crime is? So what is crime? What is crime? Act which is an offense. Act or omission which is contrary to law. If you go to the section 40 of IPC, you can find out the definition of offense there. What it says? That any act or omission which is contrary to this law is an offense. If we take it to a general form, any act or offense which is contrary to the law for time being in force is a crime. Yes or no? So mostly crime, definitions of crime are divided in two ways. Because if we go to the ancient time when the definition of crimes are first time given, at that time they give the definition of the crime according to the need of the society. Because if you go to the ancient time when the humans are dwelling in the forests, what is the rule at that time? Or the, what you call it, right of the person? 12-15. There also, why this kind of things are rules are coming at that moment? Because it is the need of the society. So definition of crime is also depend on the need of the society, so also in a legal way also. So first come to the here. Definition of the crime according to society. So moreover, first time he told that crime is an antisocial act. Nowadays also, whatever goes against the society, we termed it as a crime. Yes or no? So, any act which is an antisocial is a crime. Same way, if you go to Calvin, an act or failure to act that considered to be so detrimental to well-being of the society is judged by a prevailing standard that action cannot be entrusted to a private initiative or to haphazard method, but must be taken by the organized society in the accordance with the tested procedures. In this case, this Calvin introduced the state. That means a person cannot take or give the punishment or crime according to him. He has to give the punishment whatever there is procedure established by the state, a organized society. Yes or no? That means there is a person who is there, he has only authority to give you the punishment, head of the society. So these are some social definition of the crime. State. That means state makes a procedure. Okay, bhai, if these things you are committed, you are going to get the punishment. If you are violating that thing, you get the punishment by whom? By the state. Same thing if you go to the Jeremy Hall, Stephen, Austin, all are said the same thing in different ways. If you are committed any act or omitted to do any act which is, it is your duty to commit and you didn't do it, and there is a established law is there, then you are getting the punishment accordingly. So any act, in simple term, any act or omission which is contrary to law established or for time being in force, that is a crime. For time being in force means, take an example of NDPS, okay, that heroin, ganja, opium, all that things. Before 1985, there is different laws are there to control this kind of things, narcotic things, Opium Act and all that was there. But now that are ineffective or repealed, NDPS is there. So whatever the act or omission is there in the Opium Act 1857, 1859 or 1903 Act, that all are repealed and new act is there. Take for example in your IPC 497. What is 497? 497 adultery. Adultery is a punishable right now. It is a ground of divorce, but it is not punishable. So that particular thing is not in time being enforced. So whatever time being enforced, accordingly you get the, that if you are violating that thing or you are omitting to do that thing, you get the. Clear? So what is crime? We know that. Now tell me, when we know that a act becomes a crime, that means what is the ingredients of crime? Don't worry, it is just an introductory class because all of these things you already discussed in IPC, CRPC and all that. Mens rea, actus reus, against public. What is the ingredient of crime? That means when you are making Maggi, you need certain products. First thing, tell me, who can commit a crime? Thank you. That means a human being need an intention to commit a crime. Mens rea is there, second ingredient. Third ingredient, according to that mens rea, you are committed an act, actus reus, and due to that act, a person sustain an injury. Fourth ingredient, easy to remember. Human being, everybody, section 11, what is a person? In IPC you can get it. A group of persons, corporated, incorporated, company, registered, unregistered, or a juristic person is also come under this thing. No animal can come under section 11 unless and until a human induce that animal to commit a crime. First ingredient complete. Mens rea, that means a mental ingredient which induce you to commit a crime. That may arise out of money, out of revenge, out of jealousy, anything. Mens rea or intention in general term what we called it. Yes or no? Third one, out of that intention you committed a act, actus reus, and due to that act somebody get the injury. These four ingredients are in section 44. You get to know about what is the injury is. Mental injury, property injury, or leg. Most of you, those who are present, you are here in Tirupati from the morning. Yes or no? Many of you skip your breakfast also. Yes? Yes. Now it is already 12:30. You are hungry. Let the situation is you forgot your wallet in your house and somebody stole your mobile phone. You are hungry. What you are going to do? Hungry. You steal some food, vada or something you steal from a eatery. It is a crime? Yes or no? So what is the intention here? No sir, it is not. It is the motive. So in a particular situation when you ask that why you steal that thing, that is the motive. That means ulterior object behind your act. And just before your act, the direct will or that psychological thing which induce you to commit that act, that is your intention. Clear? That means before stealing, before that act, what is come into your mind? Okay, let's sneak into the crowd and take a vada. It is your intention. But due to that intention, why you are committing that crime? To quench your hunger. That is your motive. So, that you call na, director is always in the green room of a play. Motive is like that. A director who directs a play or film, he is always behind the camera or in the green room. Motive is like that. And your intention, which is in the stage or before the camera, that is your intention. What you did, that psychological thing is your intention. Now, again, that from IPC, what is the stages of crime? 7. You have to boil the Maggi, add the taste maker, stir it and eat it. Complete Maggi. Like that. What is the stages of crime? What thing is come first, then that, then that, then that? Intention. Okay, very good. Thank you. Preparation. Planning, preparation is there. Attempt, accomplishment. Intention, preparation, intention is never punishable. You cannot go inside someone's head to think, to look at what he is thinking. That now, right now, if I assume correctly, you are thinking that if he takes 5 more minutes, we will see him outside the gate. Yes or no? Yes. That is, I cannot prove it and you cannot get the punishment for that thing. Preparation, in general, when you are preparing to commit a crime, that means you are accumulating the weapons and all that things to commit a crime. Sometimes it is not punishable, but specific circumstances are there under section 122 of IPC, 399 of IPC, preparing to commit dacoity. Those are punishable. Attempt, act is there, but you failed. It's always punishable. Specific offences are there, like attempt to culpable homicide, attempt to murder. Those are given. 307, 308 are there. Who gives the specific punishment for the attempt? But where there is no specific punishment is prescribed for that particular offence, in that case, 511 section. 511, yes, thank you. That means, for example, theft, 379, punishment for theft, 3 years. A person cut or he cut by the other people while he is committing the theft. That means pickpocketing. It is an attempt, yes or no? In that particular case, what is the punishment? You have to go to section 511, which is said that half of the highest term given for that specific offence. That means 1.5 year maximum. Next stage is, if you passed in that act, accomplice, you get the full mark. Clear? Ingredient clear, stages clear, punishment. What are the kinds of punishment? Can anybody tell me? Death is not imprisonment, sir. Death is death sentence only. So if you go to 53 of IPC, you can find out there is 5 kinds of punishments are given under IPC, mostly followed in all the existing penal laws. Might be it is NDPS, might be it is Arms Act, might be it is any other act where the penal provision is there. First one is death sentence, Second one is life imprisonment. Third one is imprisonment, which is again divided in two ways, that is rigorous imprisonment and simple imprisonment. Fourth one is your forfeiture of property. Last one is your fine. In which cases the death sentence is given? Thank you. In rarest of the rare case, which is termed in which case? Bachchan Singh case. Bachchan Singh versus State of Punjab, 1983 or something at that moment. They, alien enemies, there is special courts are there. That means mostly if you find out that during the war, enemies are there, they are termed as POWs, prisoner of war. They are not, trial is not happen in our general courts, general criminal courts. They have their separate court and their rule is different. Rarest of rare case where the punishment, death sentence is there. Okay, take an example of your recently that person who get the death sentence. In 2008 Bombay attack, Kasab. After that, this Nirbhaya case, 2012 Nirbhaya case is also, they are get the death sentence only because of this rarest of rare case, where the court says that rarest of rare case means it is that kind of crime where the soul of the society soft. That is the rarest of rare case. You killed someone, okay, you took the pistol and fired him in a point blank range, okay. But you killed him, you first skinned him, you cut down his limbs, then you killed him. Rarest of rare case. Next, life imprisonment. Life imprisonment, term of life imprisonment is for that you have to go to three sections. Section 57 where it of IPC, where it says that what is the fraction of the life imprisonment is 20 years. Then you have to go to section 433 and 433A of CRPC, where it says that commutation of the life imprisonment. That means when an appropriate government reduces or commute the life imprisonment, it should not be less than 14 years. Sorry, it should not be more than 14 years. 14 years is the ceiling price, or ceiling imprisonment, maximum 433. It should not be more than 14 years. But in 433A it says that if there is an alternative punishment is there, which is a death sentence, or previously from death sentence his his punishment reduced to life imprisonment. In that case, the life imprisonment should not be less than 14 years. Floor right. Prisoner. That means, take an example of murder, 302, punishment for murder. Only two punishments are there. The line is like, provision is like that. Whoever commits the offense of murder, he shall be punished with either death sentence or life imprisonment. Let a person get a life imprisonment and later on the appropriate government reduce it or commute that punishment. In that case, according to section 433A, he cannot reduce it less than 14 years. take an example for the culpable homicide. Maximum punishment is life imprisonment. Yes or no? In that case, if the appropriate government wants to reduce it, it should not be more than 14 years. Yes or no? So now tell me, what is the terms of life imprisonment? Years, 14 years, 20 years. But section 57 says that it is 20 years. 433 and 433 of CRPC says 14 years. So there you can find out a case, Sangeet and another versus State of Haryana. Nearly 2014 cases it is, where specifically it was said by the Honorable Supreme Court that life imprisonment means a person had to stay behind the bar till the end of his life. Life imprisonment means, in Hindi it is called Ajivan Karavas. Till the end of your life, you have to stay behind the bar. That is the life. Imprisonment, two types: rigorous imprisonment, where you have to do some work, labor there. Simple imprisonment means you have to simply stay behind the bar. Here the question is, if in specific provision they give that here you have to get the rigorous imprisonment, here you have to give the simple imprisonment. But in some cases, some provisions are there where they don't mention, provision didn't mention that the imprisonment is rigorous or simple. In that case, it is the discretion of the court that he is going to give the rigorous imprisonment or simple imprisonment. Last, forfeiture of property, that means property is seized by the state or court. Two sections are there, I think. Section 126 and 127 of IPC, offense against state. That means you are committed some offenses, depreciation in the foreign countries, friendly nations. That property which are accumulated by that depreciation, it is seized by the court or state. That is only given in these two sections. Last one is fine, that means monetary punishment. Clear? Don't worry, this is only your refreshing of your memory, nothing more than that. Punishment done. Don't worry sir, so is not over till now. You have to go through for next few days. But the question is, why we give the punishment? What is the theory behind it to give the punishment? Which one, sir? I just know Hindi. I'm not that like that poets. I'm not that much. So there are 5 kinds of theory. That means there are 5 objects are in different ages. They give the different theories that to why we are giving the punishment. Yes, when there is the legal or our judicial fraternity is that not that much independent. That means when there is the judiciary is under the kingship or emperorship. in that case, during that time, it is, what is that theory is known as? Revenge theory. You killed me, I killed you. Simple thing. What is that theory? Retributive theory. Eye for an eye. Then preventive theory. To prevent that person to commit again that theory. Deterrent theory. To teach the society, if you are committing this kind of theory, you are going to get the same type of punishment. Next, reformative theory. Okay, every reformative theory. Next, last one is expiatory theory. What is it? What is expiatory theory? What is expiatory theory? Mostly give some fine. You heard, I think in the your Muslim law, you heard about that blood money. What is it? Yes, I killed someone and for that I give certain amount of money to their family. I am escaped from the punishment and all that things. That is the blood money, expired. So these are the objects, and right now our objective is mostly to teach the society, if you are going to do this kind of thing, you are get the same kind of punishment. And second one, to reform those persons, those who committed the crime. Clear? Thank you. Shows must goes on, right? You escape today, but tomorrow? Okay, please, sir. Sorry, it's outside.
Bring that list. Unless you take the swap, you take that, bring that list. It is into principal, sir. That's what, sir. I bring that list. Can you please bring that, sir? Sure, okay. Otherwise, you see, sir. I am completed with my subject. Let's see, sir.